only thing I could find into was 2018. 2 more years since then.
I'm sorry, I'm having a hard time hearing.
anything.
Oh,
There's one of the documents that they were required to do was the statement of taxes due. And the only thing I could find in the packet was 2018 due in 2019, and there's 2 more years after that. So I was just wondering why there wasn't a later version in the packet for.
yeah, that's a good question. I think the simple answer is because when we made the submittal in 2018, those were the current year taxes due. We'd be happy to provide that more updated version. I don't think the county nor I went back and refreshed that. Thank you. But that's something that we can easily rectify.
That was all I had.
Okay. I do have one quick question. This is Dwayne Owens, and there was a reference in the staff report, I believe on page 10, regarding Douglas County School District, a request for a tract. Is that? Can you clarify why that would be? And I'm new to this, so I'm trying to understand why that would be in our.
I think we probably can all try to answer this, but I think Jack and Jim may have also noticed that this is something I think that was left from filing 5.
I think just so because you are new, I'll explain to you what's going on here. Spring Valley actually sits on 3 different sections of land. We're on section 32, section 33, and then section 30 to the north and to the west. Amazingly, section 33 is in the Douglas County School District. That's filing 5. This is filing 6. It's still in the Elizabeth School District. So first of all, the referral should have never been sent to Douglas County anyway. And just for the record, though, we did dedicate a 25-acre school site to Douglas County schools in filing 5.
It was just a leftover comment.
I had the same question.
Anything else? Okay. Christina, in the presentation, the GIS specialist requested certain naming sequences for the roads. I just have a question on that is, did we get the naming sequence or what we want to identify roads at in policy?
I would have to confirm with our GIS analyst. I think he does have some policy that he follows, and I know he works closely with Douglas County to make sure that there's not any duplication or names that are too close to the same, so that it's better for emergency services to find places. But I think his comments were both on roads that if they connected at certain points, then they need to have the same name unless they're going completely different directions.
Right. That's and I get it. I agree with it. But if I was just hoping that we created policy to guide us in future road naming. Essentially, that's what I was kind of concerned with. Because it's good, it's happening. I'm really glad.
Danny, one of the things that we've realized over the last few years is that Douglas County actually has the final say on the road names, and I think it has a lot to do with emergency service.
Really?
And, it's really difficult actually to come up with names that are acceptable these days because all the names have been used, which is why you start to see streets with 2 and 3 names in them so that you can actually get a new name that the fire department can identify and get to the first time. So it's kind of an interesting situation here where Douglas County has a fair bit of say in what our road names are.
Okay. Well, yeah, they do still do our emergency service. Yeah. Okay. All right.
You ready?
I am ready. I don't have any other questions. Anybody else? Oh, okay.
I have one other quick question, if you don't mind.
Jennifer, actually, public comment was closed, but go ahead, please.
He didn't really answer my question, and that's why I was just wanting to make a comment. On the construction traffic going through Augusta until they build the new outlet onto 1721, after that's built, are you blocking that entrance for the construction traffic at the end of Augusta after you build that other inlet from 1721?
Well, is it okay if I answer that?
Yes, please do.
Okay, no, we can't block it because there's two points of access and it's required now, right? So, but what we can do is we can sign it. It can be something that if there's violations, they can call the county inspectors and we can get that rectified. It's going to be an easier track for the construction folks to use the north side. It's much closer to where they want to be in any event.
Okay. And then one other question, and I apologize, I don't usually go to these things, but you had mentioned earlier about the rural area, and that's why there's no sidewalks, and I'm totally fine with that, but I'm a little concerned about the safety on the road, and that was what wasn't really addressed about that, and I didn't make my point very clear, and that's why I was just trying to make it with an extra 400 cars, or say half of them come in, so another 200, 250 cars coming in on that road when there's no sidewalks and there's no shoulder. That's what I was concerned about, was the safety of walking on the road with your pets or people riding their bikes, you know, especially children and things like that. That was my concern on that road.
I mean, I note that concern. We, you know, the roads are designed for safety. The speed limits are designed for safety. You know, it's like any other street that you drive on. They're as safe as the drivers on them. So the speed limits are designed to protect the pedestrians as well as the
But was that road originally designed to include
Yes.
all this extra traffic is my question, I guess.
Oh, I'm sorry. Yes, absolutely. When the preliminary plat was approved by this county several years ago, it was platted for 1,700 units collectively. So all the roads have been designed to provide that type of capacity in their sub areas.
Considered a feeder road.
Correct. Yeah, it's a system of locals to collectors to arterials,
Yes.
and that's exactly how this is set up.
And is the speed limit going to stay at 35 on Augusta?
I believe that's true. Yes.
Okay, thank you.
Have you considered like bicycle paths or anything like that?
I'm sorry.
Have you considered bicycle paths or anything like that?
No. I mean, you know, we're in the, I don't know if it's the enviable position of sort of fitting in this piece into a filing that has already started to develop and has developed bicycle paths for a segment here where there's no bicycle paths further south. It's confusing to the public, I think. So no, we haven't discussed that.
I have one other comment on, particularly on the speed limits. Okay. In my HOA, the speed limit's 25. We have the same situation, no sidewalks, okay. But they've cut the speed limit down from 35 to 25, which makes it a lot safer. So just a consideration you might make.
I appreciate that. Thank you.
Ours is already at 25, but most people don't drive 25 on Augusta.
Call the sheriff.
Okay. All the comments, have notes? All right, I believe, Dan, you were ready?
Yes, I was. Mr. Chairman, I'd like to make a motion that we recommend approval of Spring Valley Ranch filing number 6, final plat, to the Board of County Commissioners with the 4 conditions of approval as listed.
I'll second that.
Second. The motion and a second. Dan with the motion, Peter with the second. Okay, any further discussion? And all in favor? Aye. Aye?
Aye.
Okay. Show that it was unanimous. Okay, thank you. Okay. Thank you, folks. And those who were here for this application, thank you for your comments and information. All right, let's move on to the next application. We've got the Promised Land rezone. This is a rezone of about 37, almost 38 acres from A to AR. Oh, of 1721. Christina?
Here we go. Again, Promised Land, case number RZ 210007. Rezone of 37.85 acres from agriculture A to agricultural residential AR. And the landowner is Smith Living Trust applicant representative, CJ Kirst. Again, it's 37.85 acre parcel located at 527 County Road, 1721, Elizabeth. And pre-app meeting was originally December 31st, 2020. Application was formally submitted January 20th, 2021. First referral, 21-day referral, January 26th through February 16th. And second referral was April 19th through May 3rd. Originally was scheduled for the May 18th Planning Commission and was also noticed to be on June 16th, 2021 BOCC. So here you see your aerial and zoning maps. You see the property and all the surrounding agricultural, and also in the area, the PUD, RA1, some ARs down below. So this is site description, says healthy rolling grasslands with an overall maximum grade change of approximately 100 feet from west to east. Floodplain, the closest floodplain is downhill and across County Road 1721. Wetlands, there's a short strip of riverine wetland that clips the southwest corner of the lot but does not affect the rezone. You can see that on the image there where it's at. And trees, vegetation, says there's a single deciduous tree of note and healthy significant shrubs, but none are affected, of course, by this rezone. Notification, the notice was mailed to property owners within 1,320 feet of the subject property boundaries on May 5th, 2021. Sign was posted adjacent to County Road 1721 on May 4th, 2021. And notice was posted in the Elbert County News on April 29th, 2021. This is the rezone exhibit, and we've kind of got a zoomed in copy here to see the streets a little bit better, or not streets, sorry, driveways, kind of see where that's at. How they're showing here. The application was sent to referral agencies per the Elbert County regulations. Elbert County agencies such as Public Health, the Assessor's Office, Code Compliance, and Road and Bridge. Other agencies include the Elizabeth Fire Protection District, Colorado Division of Water, Elizabeth School District, Colorado Parks and Wildlife, Kiowa Conservation District, Town of Elizabeth, and IREA. And the comments that we got, the Division of Water, they needed additional information on the pending augmentation plan, case number 2020CW3167. Applicant did respond with supplying the information from vacated case number 2007CW 223, existing well to serve parcel B and complies with requirements. Staff response is that we were waiting on a final word from the division. And I think we've gotten some information on that. That's the reference case was supposed to be finalized at that time. IREA, no objection. Existing utility easements must be included in the exhibit. The school district had no objections. They stated that cash in lieu and improvement fees will be due at the time of subdivision. Elizabeth Fire Protection had no objection. They asked proper address signage be placed at the split in the driveway. Public Health had no objection, and Code Compliance had no objection, said there were compliance issues. There will be conditions of approval. So here below, staff comment, existing unpermitted modular home located on the rear of the property needs to be sited on parcel A and permitted. A second unpermitted modular is located at the front of the property, and this unit either needs to be sited and permitted or gotten rid of altogether. So rezoning criteria are Article 3C4 of the Elbert County zoning regulations and lists criteria A through F for all rezone requests. And those criteria are as follows. A, whether the proposed rezoning conforms to and is generally consistent with the goals and policies of the Elbert County Comprehensive Plan. B, whether proposed rezoning is compatible with surrounding land uses. C, whether proposed rezoning would adversely impact the provisions of public services. D, whether proposed rezoning would adversely impact the environment. E, whether the proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. And F, whether proposed rezoning will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. So similar to the last, although not quite as detailed, I think. Some of our goals from our comprehensive plan, underneath the residential development on page 55 states Elbert County supports residential development by encouraging a range of lot sizes and residential densities associated with available roads and infrastructure, and by encouraging the designation of open space and preservation of areas of visual, historic, and natural consequences. So there's two transportation policies here listed. TR1, which states new development is encouraged to locate proximate to approved arterial roads, or such roads should be provided by developer. And TR2, which states proposed roadway systems should be planned to minimize negative impacts on the environment and to adjacent land uses. Down below here in the staff evaluation, it states that the site is located on the existing improved thoroughfare of County Road 1721, thus fulfilling the goal of TR1. And the proposed access will be constructed to county standards and will provide access to both parcels A and B, thus complying with policy of TR2 by avoiding multiple access points. And the residential policy RD2 states to preserve open space and preserve the rural character of Elbert County, clustered residential development patterns are encouraged on lands within 1 mile of paved roads and existing utility corridors where they exist, and within the 3-mile service and or influence areas of county towns. Approval of this rezone to agricultural residential AR would allow the landowners to subdivide this property into a total of 2 lots per policy RD2 and the Elbert County residential development goals. So based on Article 3C4 of the Elbert County zoning regulations, staff finds that A, the proposal is in general conformance with the Elbert County Comprehensive Plan. B, the proposal meets the criteria for approval in the Elbert County zoning regulations. C, the Elbert County subdivision regulations are not applicable to the rezoning application. D, the proposal is compatible with existing and allowable land uses in the surrounding area. Somehow I'm off here, because I believe that should say E. Proposal will not result in significant impact to the health, safety, welfare of residents and landowners in the surrounding area. So staff recommends that the Plan Commission recommend approval to the Board of County Commissioners of the rezone of Promised Land RZ 210007, subject to conditions 1 through 3. 1, the applicant will be required to remove the public hearing sign within 7 days of approval by the Board of County Commissioners. 2, the rezone shall not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded. And 3, recordation of all appropriate documentation to occur within 180 days of the Board of County Commissioners' approval. Thank you.
Christina, thank you. DJ? All right.
Good evening, Commissioners. CJ Kirst, Tahoe Consulting, 5730 East Otero Avenue, Centennial, Colorado, 80112. Christina did a really good job of explaining it. It's a very basic rezone from agriculture to agriculture residential, really for the benefit of subdividing this into 2 separate lots. Just to add on to something she was saying about the water decree was issued on April 27th. And I'm happy to provide it if they don't have it already, but that is that was really the only loose end I think that needed to be addressed. Everything else is pretty rudimentary when you think about it. Access is off of 1721. I just spoke about the water. Obviously, we'll use on-site wastewater treatment systems. And, you know, the addition of 1 lot is really not creating any sort of impact at 1721. There are no drainage impacts here. So I believe it's a good use, a good rezone. It fits in with the surrounding area very well. So I can answer any questions anybody has.
All right. Questions? No? Do we have any questions on Zoom? Anybody, Christina? Okay. On the table.
Roger. Yeah, a couple questions. On one of the IREA comments, it asked for an easement for the existing, I think it's an existing power line that goes from the front of the lot up to the existing house. And on the plat, I don't see that easement. I don't know if that was something they still are requiring or.
Go ahead and answer it. Okay.
Please do.
Can I show you?
Sure. Okay, the one I'm referring to is this, they have a comment right here that they want to have an easement for this line that serves existing house. And that made sense to me, so I wanted to find out.
What they were wanting was an easement on this line.
Okay, I saw that.
This goes to the house, so this is after.
So that's private?
Private,
Okay,
right.
okay,
We did add the easement on this line.
okay. I saw that. That's good. That answers that question. Second one is when I was out to the site, I did notice the modular, and I believe that the circle that's put on parcel A is where that existing modular that's just sitting there is going to be put on a foundation and rehabbed essentially.
Correct. That's the general location that we'll move it to be in compliance with the agriculture residential setback.
Okay. And then the second part is the unpermitted shed and the, I think another building that's on the site that's not permitted.
Yeah, we've been in communication with the zoning compliance department about all of this. I think what you're talking about when you talk about the shed, maybe the trailer that is on wheels. There is electrical equipment in there, as one of the family members runs a electrical contracting business. So it's really just being used for storage and can be moved around. We're going to continue to work with the county to make sure everything is compliant.
Okay, and that's what I saw. There's like an Airstream type trailer up there. And then next to that is that, it looks like a homemade trailer that's got wheels. That's the one you're talking about.
That's the storage,
The one that's unpermitted.
Yeah, I don't think there's anything that's not in compliance as it relates to the Airstream.
Oh, no,
RV.
I'm
right.
It looks like that's just like being parked there.
Right.
But it's right next to the
Right next to it,
building
yes.
that's kind of questionable.
Right.
And then on the front of parcel parcel B, on the front, which would be east of the existing house, there's also a shed down there closer to 1721. And I assume that that is a legal building. It wasn't commented.
You want to answer it? Okay, so that's the trailer that we're talking about.
They're not permanently. I talked to Mike Moore, and he said that, as long as it supply storage and electrical storage.
Okay, well, then that brings up another question. There are two sheds I'm seeing on the property. I'm not sure which one we're talking about. There's the one that's up west of the existing house. It's kind of on the top of the hill that has wheels under it. That's the one I thought you were talking about that's for storage.
No, I think that's the one that we're going to move and put on a foundation.
No.
No?
There's the modular.
Do you want her to come up here?
Yeah.
Does it matter?
Have her come up
The only
so I can
thing
hear
I
her.
have, you were working with the inspector in the county at this point, right? You're working with Mike in the county, and he has been out to your property, and he is aware of what you are trying to do with the rezone. So he is giving you everything that you need to do to. Okay. So what I would say at this point, if we've got concerns about the building, who that needs to go between is between our inspector and the county, because it appears they've already, in this application, and according to you, he has already been out there, inspected it, and actually is aware of you going forward with the rezone.
Yeah, he actually provided referral comments, so we addressed him like we would the school district or.
Yeah. So I'm kind of wondering, if we're going, we as a group, if we're going somewhere else with this, then it sounds like it's already handled through Mike, through our inspector in the county.
That's correct. There's an ongoing line of communication going back and forth.
Okay, that's what it sounds like. So, Roger, I don't know if we're trying to going someplace what they're actually working on. I don't know. So, but I think from what I saw here and what I've heard, there was a lot of interaction with the county and the inspector on what they have to do with those buildings that are existing now. So.
Danny, there's a letter from Mike that basically says that he's okay with everything as long as they address the violations, and we're going to assume that you're going to do that.
That's what I thought. I thought we're going kind of overboard looking at something if he's already addressed it and he's put it in the application and he's done that as a referral, and we're hearing that from you also, and pretty much we're going in an area where it's already taken care of.
Yeah. Yep.
Okay.
Okay. I want to make sure it was brought up.
Okay. Point taken. So, Roger, what else? Did you have some others? Okay. Dan.
My questions were answered.
Okay. Okay. Peter.
Oh, I just had one question that was unclear to me in there. I was talking about the culvert requirements across 1721 and the drainage over, that could over amp that culvert. And I couldn't see where that was at.
I'm sorry, I had a hard time hearing.
There was a culvert in the 2N civil letter. It mentioned that the water drainage could overflow the culvert.
Yeah.
And I couldn't see where that was at.
Where the culvert is?
Yeah. I drove up and down there and it just wasn't clear to me a really big culvert. The whole thing comes down to 1721.
Isn't helping. I understand how you're in a hard time seeing it, but I believe that that's here at design point one is triangle, because you can see how the topo kind of creates a tail or a swale or a draw. Yeah. So this has got to be right.
I'll take another look on the way home. And I got one question for Christina. Your zoning map, south of 166, you got two XX zoning lots on your map that you used.
And I believe, Christina, most of those XXs were, we did, I think, 3 hearings.
Right.
The commissioners kind of cleaned up pretty much all of them. The only thing we probably should check and see if those were just existing from the old thing and they've been rezoned, or if it's really made.
That's why I was asking, because I was part of that.
Yeah, it was, yeah.
And I know that they were all supposed to be taken care of, and we weren't supposed to have any more of them. So I don't know whether the map wasn't updated
Yeah,
or they were overlooked.
and that's something we might want to check. I believe there were 3 hearings.
There were.
Yeah, and we had this. I thought we cleaned most of them. I thought we cleaned them all up, actually.
I thought the only one we might have had left was south of Elbert. I'm trying to remember if we took care of that one in the last round.
We had,
So-
Yeah,
we had that special one, that's something that was urgent that we do right away, and then we had 2 groups we'd
Mhm.
after that. And I thought they were all taken care of.
so
So,
that'd be something to look at.
Yes, sir.
Okay, what else? Peter?
I think that's it.
Good. Dan? Hey. Good? Arthur? Dan?
Yep.
All right. Let's have a vote. Can I have a motion?
Mr. Chairman, I'd like to make a motion that we recommend approval of Promised Land RZ -21-0007, subject to the 3 conditions which are standard on the back.
Okay. Have a second.
I'll second it.
All right, thank you. Got a motion from Dan, a second from Peter. All right, any further discussion? Hearing none. All in favor?
Aye.
Aye. All right. Okay, thank you. We have the third and final, we have Swift Creek rezone, 34 acres from A to AR.
This one's interesting.
Yeah.
Okay, so Swift Creek rezone is case number RZ210005. It's a rezone of 34 acres from agriculture A to agricultural residential AR. And the landowner is Mary L. Cockrell and Robert M. Kellert. Applicant representative Tom Roney is on Zoom. Again, it's 34-acre piece of property located at 39750 Transition Terrace, Elizabeth. There's a note down below here that says first address assigned to this property not reflected in original application. I think we had some address confusion when this first came in. Pre-app meeting was December 3rd, 2020. Formal application was submitted January 13th, 2021. First referral was February 3rd through 24th. And the second referral was March 24th through April 7th. Again, this was an item that was supposed to be on the May 18th Plan Commission and was noticed for the June 16th Board of County Commissioners. So here you see the zoning, the aerial maps. You can see there's a lot of agricultural in there, but there are some AR in that area there, and AR1, I believe. So the site description, subtly rolling grasslands with no major topographic features. A home is currently being built in the approximate center, east to west of the lot. This home is for the owners and is cited to work within the proposed rezone minor plat requirements. Wetlands, floodplains, the closest floodplain is south of the lot and across Transition Terrace. And we have on the side here, the wetlands map. There are no wetlands that are identified on this site, so that you can see that there are some in the vicinity. They're just not on this property. Trees and vegetation, there are a few trees scattered across the property, but native prairie grasslands dominate. Notice for the hearing was originally noticed to property owners within 1,320 feet of the property boundaries on April 19th, 2021. Sign was posted adjacent to Transition Terrace on May 3rd, 2021. And notice was published in the Elbert County News on April 29th, 2021. So here's the rezone exhibit. There's red lines on here showing some of the corrections that are in progress or forthcoming. And referrals were sent out to the county agencies, Public Health Assessor's Office, Road and Bridge, and non-county agencies, Elizabeth Fire Protection District, Colorado Division of Water Resources, Elizabeth School District, Colorado Parks and Wildlife, Kiowa Conservation District, the Town of Elizabeth, and IREA. So some of the comments we received, the Division of Water Resources, their first referral comment said they needed additional information to determine adequacy of supply. They asked for a couple things: proposed withdrawal and proposed uses, clarify proposed sources since augmentation plan 2003 CW 390 accounts for 100 years, and proof of water rights. In the second referral, they recommend that the county determine the appropriateness of requiring development of renewable water resources to serve longer, potentially than 100 years. This was a very interesting one, the way it was worded. And we've seen this on a few things where they've got adequate water the way it's stated, but then they're asking for us to have some more renewable resources, and that goes back to some of the policies and goals that we have in the comprehensive plan talking about encouraging renewable resources. IREA, no objection. They had an additional easement that will be required to cross the 60-foot right-of-way, but that will be handled at the time of electrical design. Elizabeth Fire Protection had no objection. They stated there's a cash in lieu of fire flow, 1,040 per new lot due at time of subdivision. Public Health had no objection, and Kiowa Conservation District had no objection. We did receive a public comment from a Richard Beveridge, 3524 Ferns Road, Elizabeth, neighboring the RA1 property to the west. He was concerned about allowed access via transition terrace. Staff comment here is proof of existing access easement on book 12, page 95, shows entirety of the right-of-way easement being within property lines of 3524 Ferns Road, aka the lot 1 from more development. Rezone criteria, as we've talked about before, in Article 3C4 of the Elbert County zoning regulations, list review criteria A through F for all rezone requests. A, whether the proposed rezone conforms to and is generally consistent with the goals and policies of the Elbert County Comprehensive Plan. B, whether proposed rezone is compatible with surrounding land uses. C, whether the proposed rezoning would adversely impact the provisions of public services. D, whether the proposed rezoning would adversely impact the environment. E, whether proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. And F, whether proposed rezoning will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. So along with that review with the comprehensive plan, looking at, again, those land use goals for residential development, stated previously with the other applications, Elbert County supports residential development by encouraging a range of lot sizes and residential densities associated with available roads and infrastructure, and by encouraging the designation of open space and the preservation of areas of visual, historic, and natural consequences. Two that are called out on this application are policy TR1 and transportation. This states new development is encouraged to locate proximate to improved arterial roads, or such roads should be provided by the developer. And policy RD2 under the residential piece, which states to preserve open space and preserve the rural character of Elbert County, clustered residential development patterns are encouraged on lands within 1 mile of paved roads and existing utility corridors where they exist and within the 3-mile service and or influence areas of county towns. The staff evaluation related to these two is first that the site is located in close proximity to the existing improved thoroughfare of County Road 13, thus fulfilling the policy goal TR1. And also approval of this rezone to agricultural residential would allow the landowner to subdivide this property into a total of 3 lots per policy RD2 and the Elbert County residential development goals. These lots being 10 plus acres each will be larger than the existing residential development zoned mobile home to the north, thus preserving open rural living character. So based on the Article 3C4 of the Elbert County zoning regulations, staff finds the following. A, the proposal is in general conformance with the Elbert County Comprehensive Plan. B, the proposal meets the criteria for approval in the Elbert County zoning regulations. C, the Elbert County subdivision regulations are not applicable to the rezoning applications. D, the proposal is compatible with existing allowable land uses in the surrounding area. And E, this proposal will not result in significant impact to health, safety, and welfare of the residents and landowners of the surrounding area. So staff recommends the Planning Commission recommend approval to the Board of County Commissioners for the rezone of Swift Creek RZ 210005, subject to conditions 1 through 3. The applicant will be required to remove the public hearing signs within 7 days of approval by the Board of County Commissioners. 2, the rezone shall not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded. And 3, recordation of all appropriate documentation to occur within 180 days of Board of County Commissioners approval. Thank you.
Christina, thank you.
All right, I believe the applicant representative is, Tom,
Yes, sir.
are you out there? Do you have,
Can you hear me?
go ahead.
Yeah, I really don't have anything else to add. Christina's done, as usual, very thorough job, as is Jen and Greg. I'm really sorry that they're not going to be here anymore, but we just move onward and upward. It's a pretty straightforward application. And if you have any additional questions, I'd be happy to answer them for you.
Thank you. On Zoom, do you have any questions? You got anybody still out there? Seeing none, do you see any, Christine?
No, we still have some folks out here, but I don't see any raised hands.
So, shall we go down the table? Roger?
Okay. I have comments. Oh, yeah. In looking at the application, everything seems to be in order except I'd like an explanation, Mr. Maroney, about the water rights and whether or not the water rights have been conveyed in order to make the water adequate for the other two lots.
Yes, sir, they have. Oh, excuse me, I apologize. Go ahead.
Okay, well, what it is the first time they came back on March 26, of course, there was the applicants, somebody else owns the water rights. And this second letter from the Colorado Division of Water Resources stated that any application must include evidence that the applicants have acquired the right to the portion of water being requested for the application. And one of the questions I have is that, do you have, in fact, because it's not in the packet, that you have purchased and or have the water rights?
Yes, sir. The water rights were conveyed at closing when the applicants or the owners actually purchased the property. And we had to supply evidence to the state that they actually were conveyed. And our water attorney, Eric Trout from Petrock and Fendel, supplied that information to the state, and the state said that it was adequate and that we have an augmentation plan that has been approved.
Okay, so my next question is to Christina. I'm sorry, but Christina, when this comes through, this is going to be an administrative, and you're going to be working with this after the rezone. And the question I have is that it was unclear to me about this within the packet. I could not determine that they actually had the water right. And when it comes through, and this is going to become from agricultural to actually residential, agricultural residential, I have a question because we're never going to see this again. Let's say the water was not conveyed, then why would we want to send this to the Board of County Commissioners without a stipulation or talking about the water? It can't be a residential lot without water, essentially. So that's why in our approval, I'm just asking the question because if it was going to come back before us or before the Board of County Commissioners, they would have to have that information also. So it was not addressed in what I call the findings. I mean, you did write a little note about it, but I had to dig into the two water decree things. So should we be considering, and I'm asking the chairman here and others along the board, should we be considering one when the water supplies?
Well, there's an approval of the water rights in the packet.
Well, the water rights belong to somebody else though. Not, there's two sets of names here. And there's confusion. And the state caught it.
They'd also provided the approval.
Yeah.
Well, the state said in their second letter, well, what do you?
Yeah, no, but it's just on the application.
Yeah, so I'm just looking at, there's two questions actually here. One, he says they purchased the water rights. It wasn't in our packet. So I don't know they had the water rights. That's item one. Now we have a verbal on it.
The applicant told us they could make the right.
So they have the rights. But but we didn't know that until just now.
Well, we do know it now.
Now we know it now.
So I imagine, Dan, I do imagine that he had to provide the state. Tom, did you have to?
Yes, sir. Yes, sir. Yes, on the first referral back from the state, they wanted clarification on the transfer of the water rights from the purchase, which we provided to the state. And the second referral came back and they said our water supply is adequate. And they've approved the augmentation plan. It's already gone through court. The augmentation plan is complete. We did not have to do an adjudication because the water was adjudicated probably 10, 15 years ago. And with the transfer of the property, the water rights also were transferred. And the state made that determination on our, when we went back to their referral request on the first referral. So they have determined that that the rights are there and that our augmentation plan is in place and approved by the court.
Okay.
And he had to.
Which we did. Which we went back to.
Right. I understand. Yeah. Okay. And like I said, it's just that I did not have that information until just a minute ago.
You know, hey, Dan, I understand because it was a little confusing and that's why we had to clarify it. And I appreciate your comment, which is really good. But those rights were determined 10 or 15 years ago and they were transferred with the property. The state just needed to see that they were, which we provided to them. And thus, they approved the augmentation plan. Otherwise, they would not have approved the augmentation plan.
Okay. Okay, I'll pass.
But Dan, good question.
No,
good question.
I'm just saying it was in both of them.
Okay.
That's why I brought it up.
Good. Good. No, no, it's a great question. Great question. You keep me on my toes.
Peter, what do you got? Dan?
Nothing. Actually, I do have one other question. There was a letter written about the road, the name of the road. Has that been cleared up, Tom?
Yes, sir. Yes, sir. We one of the neighbors. This was in the very beginning of the process. Just so you know, that had just purchased a piece of property just to the southwest of here. And they're not from around here, and they thought that they owned the road. And so, unfortunately, we had to get council involved and let them know that this is a 60-foot non-exclusive easement for ingress and egress. And actually in the, I sent Jen, who was the planner, an email from those neighbors. It was probably 3 or 4 weeks ago, and they said that they were mistaken, and this is in the file, and that they apologized, and they're all good. So it just was something that we had to deal with.
Okay. That answers my question.
Okay.
Thank you.
And
I'm good.
got any more? Okay.
Just want to. How is it part? How is this?
Okay, so we have no other comments or questions? Can I have a motion?
Go ahead. We'll make it a fair tonight about second.
Okay,
Motion.
please.
I can make a motion to approve the Fifth Creek rezone, RV 21-0005.
Subject to the conditions.
Conditions that
You can listen. Listen. How many are on? There's three conditions.
of the standard conditions.
There you go.
Conditions.
Good enough. Christina, I'll second it. Okay. Any further discussion? Okay, then all in favor?
Aye.
Thank you, gentlemen.
Tom, thank you.
I appreciate it. God bless you guys.
Too.
Bye-bye.
All right. We have a motion to adjourn.
Oh, I'll make that motion to adjourn.
I'll second it.
Okay, all in favor?
Aye.
Thank you, folks.
So, any other action?
Recording stopped.